Welcome to CM Guide podcast series. Today we're embarking on a deep dive into something crucial yet often overlooked: how people get paid in the construction industry, specifically in Tasmania, Australia. If you've ever wondered about the legal shortcuts to ensuring fair and prompt payments in a complex world, well, this deep dive is definitely for you. We'll unpack the core ideas behind the Security of Payment Act in Tasmania, explore its development, and walk you through the mechanisms designed to keep that all-important cash flowing. So what does this all mean for you if you're involved in construction, or maybe just curious about how these intricate legal frameworks operate? All right, let's unpack this then. We're talking about the Building and Construction Industry Security of Payment Act 2009 in Tasmania, often just called the TAS Act, right? What exactly is its driving philosophy? And I guess, why was a piece of legislation like this even necessary in the first place?
Yeah, that's right, the TAS Act. At its heart, it's really a fundamental piece of legislation. It's designed to ensure, well, continuity of payment. For anyone undertaking construction work or supplying related goods and services under a construction contract in Tasmania, think of it as a vital lifeline almost, a guaranteed channel for money to flow, especially in an industry where cash flow can be incredibly tight and often quite precarious.
A lifeline, I like that. So it's about keeping money moving.
Exactly. Its core objective is to ensure that money keeps moving swiftly and reliably down the contractual chain, from the client to the head contractor, then flowing down to subcontractors, and finally to the material suppliers.
Okay, that makes sense.
And what's truly crucial to grasp here is that this entitlement, this right to receive and recover progress payments, it exists regardless of whether your contract explicitly provides for them.
Really? Even if the contract doesn't mention progress payments?
That's right. The Act essentially steps in. It's there to prevent those frustrating and often crippling situations where payments are delayed or outright denied, maybe because of, manufacturer disputes or even during challenging financial periods like those quiet holiday shutdowns we sometimes see. It directly addresses a very real, pervasive problem in the construction sector, where just one payment delay can cascade, creating this domino effect that cripples businesses further down the chain.
Ah, the domino effect. I can see how that would happen.
Yeah, if a subcontractor isn't paid, well, they can't pay their suppliers. Those suppliers then can't pay their staff, and suddenly entire projects just grind to a halt. The Act is designed to protect the financial health of the entire industry by prioritizing that continuous flow of funds.
So it sounds like it's about much more than just sorting out disagreements. It's about making sure the whole financial engine of a project doesn't seize up. That immediately brings to mind that phrase you hear a lot: pay now, argue later. Can you really explain what that means in practice for someone, say, working on a building site in Tasmania?
Absolutely. The pay now, argue later principle is absolutely foundational to this Act. It's really what gives it so much practical power. It establishes a fast, enforceable pathway to recover money owed without needing to go through those incredibly lengthy and frankly expensive traditional legal proceedings.
Yeah.
Court battles that can drag on for years.
By avoiding the courts if possible.
Exactly. The Act prioritizes getting money into the hands of those who've done the work or supplied the materials. Because, let's face it, if they don't get paid, the projects simply start moving. It's a proactive measure designed to prevent cash flow from grinding to an immediate halt the moment a disagreement pops up.
Okay, so give us an example. How does it work?
Okay, imagine a common scenario. A dispute arises over the quality of some painting work, maybe, or whether a variation order for extra work was properly issued. Under traditional contract law, payment for that work might be withheld indefinitely while the dispute gets litigated. Could be months, even years. The TAS Act fundamentally flips this on its head. The payment for the work performed, it must be made first. The Act demands immediate payment for that completed work. Only after that payment is made can the parties fully pursue their underlying arguments or claims, perhaps through arbitration or mediation or even full-blown litigation outside the Act's immediate fast-track process.
Ah, I see. So the payment comes first, the detailed argument comes second.
Precisely. It ensures that the financial stability of the party performing the work isn't jeopardized by a drawn-out argument over an issue that, in the grand scheme of the project, might later prove to be relatively minor. It effectively separates the immediate cash flow issue from the long-term dispute resolution. It prioritizes the economic health of the contractor or supplier.
So just to clarify for everyone listening, it's not saying the argument just disappears forever, right? It's just saying, let's deal with the financial urgency first, keep the wheels turning, and then we can sort out the finer points of the contract later. Is that about right?
That's exactly it. It's vital to understand that while it offers quick resolution for progress payments, the Act does not definitively settle underlying disputes about defects, delays, or variations in the long term. Parties are explicitly free to pursue those broader claims later. For instance, if an adjudicator decides a certain amount is due and that payment is made, but later, perhaps in a full court proceeding, it's proven that there were significant defects that reduced the value of the work, well, the party who made the payment can potentially recover that money back.
Okay, so it's not the final word on the dispute itself.
No. The Act is a mechanism for prompt payment and maintaining cash flow, not necessarily for the final, definitive, and comprehensive resolution of all contractual disagreements. You could think of it as a bridge to keep the project moving, not the final destination of absolute legal certainty.
That's a helpful way to put it. And what's particularly interesting, maybe even surprising to some, is how widely this act applies. I read somewhere it even binds the Tasmanian government itself. Can you elaborate on the significance of that?
That's a truly fascinating and, yeah, often surprising aspect. The Tas Act binds the Crown. That's legal speak for saying it applies to the Tasmanian government itself.
Wow. So even government projects.
Absolutely. Think about the power dynamic this shifts.
Yeah.
Even when you're working on a massive public infrastructure project, say a new hospital, a major road upgrade, or even a school, and your client is the government itself, you have the same legal pathway to ensure prompt payment under this act. This isn't just a legal nicety, it demonstrates the Act's profound commitment to, well, leveling the playing field somewhat.
That's quite significant.
It is. It ensures that no single entity, no matter how powerful or large, can arbitrarily delay payments in construction. It underscores that payment security isn't just for private disputes, but a foundational public policy for the entire industry, holding even the state to account. It's a strong statement that prompt payment is essential for everyone involved in building Tasmania.
That truly sounds like a critical piece of legislation, really designed to tackle a persistent challenge in construction. But how did Tasmania arrive at this particular act? Can you walk us through its development and sort of how it fits into a bigger Australian legal picture?
Certainly. The TAS Act came into operation on December 17, 2009. It wasn't the first of its kind in Australia, though. It was actually the sixth piece of legislation of its nature to be introduced across the country.
Oh, okay, so there was a trend.
Exactly. It highlights a national movement, a recognition that payment security was a systemic issue needing legislative intervention pretty much everywhere. This wasn't an isolated Tasmanian initiative. It was part of a broader, arguably harmonized effort across the country to address common industry pain points, recognizing that similar problems often required, well, similar solutions.
And I understand it's based on legislation from another state.
That's right. Crucially, the TAS Act is closely modeled on the Building and Construction Industry Security of Payment Act 1999 from New South Wales. This isn't just a coincidence or, a legislative shortcut. It means the Tasmanian Act shares many of the same patterns, procedures, and core features. Features that had been tried, tested, and refined in New South Wales for a full decade before Tasmania adopted its own version.
10 years of experience baked in, effectively.
Pretty much. And this modeling isn't just a historical footnote. It has very significant practical implications for anyone involved in construction in Tasmania today.
So, because of this close resemblance, does that mean legal decisions or precedents from New South Wales carry a lot of weight in Tasmanian courts when they're interpreting this act?
Absolutely. Because of these substantial similarities, Tasmanian courts frequently look to, and are indeed heavily influenced by, legal authorities and interpretations established in New South Wales. This alignment is expected to continue, providing a vital degree of consistency in how these laws are applied across state lines, even though the legislation itself is state-specific.
So for lawyers and businesses, that's helpful.
Very helpful. It means you can often draw on a larger, more mature body of case law and precedents when advising clients or making decisions in Tasmania. It's like having a rich library of legal wisdom readily available thanks to the groundwork laid in New South Wales. It brings a degree of predictability to an otherwise complex legal area, making it a bit easier to forecast outcomes and advise on strategy.
That's a great point about the legal precedents and consistency. It definitely helps to have that existing framework to draw on. But despite that solid foundation, were there ever any major pushes to actually change or update the Act after its initial rollout back in 2009? Has it evolved?
Yes, there certainly were attempts. In October 2015, there were significant reform efforts underway. A package of relevant legislation was introduced into Parliament as a direct result of a broader building regulatory framework review that had started back in July 2014.
A big review then.
Yeah, it was a comprehensive look at the entire regulatory landscape for building in Tasmania, and naturally, enhancing security of payment was a key component of that discussion. This reform package included two key bills: the Residential Building Work Contracts and Dispute Resolution Bill 2015, and the Building and Construction Industry Security of Payment Amendment Bill 2015.
And what was the aim of those bills?
They aim to modernize and potentially refine various aspects of the Act, perhaps addressing issues that had emerged since its inception, or maybe incorporating best practices from other jurisdictions that had updated their own security of payment laws in the meantime. However, both of these bills ultimately lapsed.
Lapsed. Meaning they didn't become law.
Correct. They didn't pass through Parliament. So for all intents and purposes, the TAS Act largely remains in its original 2009 form, despite these attempts at modernization. This means the core framework and its distinct features, which we should probably discuss next, have remained remarkably consistent for well over a decade now, providing a stable, if perhaps not rapidly evolving, legal environment.
It's interesting how it's remained so stable despite those attempts at reform. You mentioned the TAS Act is closely modeled on the New South Wales Act, but Tasmania isn't just a carbon copy, is it? You mentioned distinct features. What are some of those key elements where Tasmania decided to sort of forge its own path, distinguishing its act from the model?
That's an excellent question, and it's where the nuances of the TAS Act really start to emerge. Despite the strong similarities, there are indeed some important distinctions that you, as a participant in the Tasmanian construction industry, should be acutely aware of, because these can significantly impact how the Act applies in specific situations. These aren't just minor tweaks. They reflect Tasmania's particular approach to certain aspects of construction and payment security.
Okay, let's dive into those differences. What's first?
First, and this is a significant divergence from some other jurisdictions, the TAS Act explicitly includes residential structures within its operation.
Residential, so like people's homes.
Exactly. This means Class 1 or Class 10 buildings, as defined by the Building Code of Australia, are covered. To put that into perspective, Class 1 generally refers to single dwelling houses, or townhouses basically, where people live. Class 10 covers non-habitable structures like sheds, carports, and fences. This is a very significant inclusion. It means homeowners engaging builders for new homes, major renovations, or even just building a garage are part of this payment security framework.
Even if it's just their own home they live in.
Yes, and importantly, it applies regardless of whether the owner resides or intends to reside at the premises. So it covers speculative residential developments or holiday homes too. It ensures comprehensive coverage across the residential sector, which is, a huge part of the construction economy in Tassie.
Right, that's a big one. What else is different?
Next, we have a truly fascinating point regarding its extraterritorial reach. The TAS Act can apply to contracts for the supply of building or construction-related goods and services by a person in Tasmania, even if the actual building or construction work is carried out outside Tasmania.
Outside Tasmania, how does that work?
Let me give you an example. Imagine a Tasmanian engineering firm. They design specialized prefabricated components for a major project in, say, Victoria. Or maybe they supply expert project management services from their Tasmanian office to a site up in Queensland. While the physical construction is happening elsewhere, if that Tasmanian company is supplying goods or services from within Tasmania, they could potentially rely on the TAS Act to secure payment for those goods or services.
Wow, that really broadens its scope.
It does. It significantly widens its practical scope beyond just work physically performed within Tasmania's borders. It recognizes the interconnected nature of modern supply chains and where businesses are based.
Okay, interesting. What other distinctions are there?
Another key difference involves generous timeframes for residential respondents. For payment claims specifically related to residential structures, where the respondent is the owner of the land and not a building practitioner, so essentially your typical homeowner, they are allowed 20 business days to serve a payment schedule and make the payment.
20 days, that's longer than usual.
It is. For all other types of respondents, like commercial developers or head contractors, the standard is a much tighter 10 business days. This longer period for residential owners is a practical acknowledgement that homeowners might be less familiar with rapid commercial practices and legal deadlines. It gives them a bit more breathing room to understand and respond to a formal payment claim. It's a balance between speed and practicality for individuals.
That seems fair. Anything else on timeframes?
Yes. Furthermore, we see longer adjudication response timeframes across the board compared to the New South Wales model. All respondents under the TAS Act are given double the time compared to the New South Wales Act to serve an adjudication response. They have the later of 10 business days after receiving a copy of the adjudication application, or are 5 business days after receiving notice of an adjudicator's acceptance of the application.
Double the time. That's quite a bit more breathing room.
It is, and it can be crucial in what is typically a very high-pressure process. This extra time can be vital for a respondent to thoroughly prepare their case, gather all the necessary documentation, and formulate a detailed response to an adjudication application, potentially leading to more robust and well-considered determinations. In a process designed for speed, this additional time for a response is a noteworthy feature in Tasmania.
Okay, what about flexibility in the process? Can you pull out if things change?
Yes, there's flexibility in the withdrawal of adjudication application. A claimant has the ability to withdraw an adjudication application at any time before the application is determined, simply by providing written notice to both the respondent and the adjudicator.
Why would someone do that?
Well, it's a practical feature. For instance, if the respondent suddenly makes the full payment after the application is lodged, maybe the pressure worked. Or if the claimant realizes there's a procedural flaw in their own application that could jeopardize it, they can pull back rather than risk a negative determination. However, it's crucial to remember the claimant may still be liable for the adjudicator's fees and expenses incurred up to that point.
So withdrawing isn't necessarily free.
Not necessarily, no. You might still have to cover the adjudicator's time spent up to that point.
Makes sense. What about modern communication? Does the Act keep up?
It does. On a more modern note, the Act explicitly permits electronic service. This means the service of notice by email or any other electronic method is perfectly valid, provided, and this is the key bit, that the recipient has agreed to this method of service beforehand.
Agreed beforehand, so you can't just email it out of the blue.
Exactly. You can't just fire off an email and assume it's valid if there's no pre-existing agreement, usually in the contract or through some other clear consent, for electronic service. But where that agreement exists, it really speeds up what can often be a time-sensitive legal process, reducing reliance on slower, traditional postal methods.
Good to know. And you mentioned one more unique feature, something about costs.
Yes, and this is a truly innovative and, I think, powerful feature. The adjudicator's power to award costs. Unlike many other similar processes in other places, an adjudicator in Tasmania has the power to determine that one party must pay some or all of the costs incurred by the other party.
Costs like legal fees.
Potentially, yes, but this power is specifically reserved for instances of frivolous or vexatious conduct, or for the making of clearly unfounded submissions by the first party. Imagine you're a small subcontractor and a larger company tries to bury you in frivolous objections just to delay payment, maybe hoping you'll just give up because you can't afford the fight.
Yeah, that happens.
Well, in many legal processes, simply raising a bad argument costs nothing extra to the party raising it, beyond their own legal fees. But here, the adjudicator can say, no, this argument was clearly baseless, designed simply to drag things out, and they can then make that larger company responsible for your costs incurred in dealing with that nonsense.
Wow, that could really change the game.
It fundamentally changes the calculus for parties considering delaying tactics or making unfounded claims. It fosters a more honest and efficient dispute resolution environment. It acts as a significant disincentive against abusive tactics during the adjudication process, adding a layer of fairness and actively discouraging bad faith practices.
Those distinctions are really important to highlight, especially for businesses maybe operating across state lines or dealing with residential projects here in Tassie. So, with that in mind, what types of construction contracts does the TAS Act actually cover? And just as importantly, are there any specific situations where it doesn't apply at all?
Okay, scope and limitations. The TAS Act is quite broad in its application, and that's intentional. It's designed to cast a wide net and cover most scenarios within the construction industry. It applies to any construction contract, whether that contract is written, oral, or partly both, for construction work carried out within Tasmania.
Even oral contracts.
Yes, that flexibility in contract form is incredibly important because in the real world of construction, agreements aren't always fully formalized on paper. Sometimes a handshake deal or series of emails forms the basis of a contractual agreement, and the Act recognizes that reality. And as we discussed with the extraterritorial reach, it also extends to the supply of construction-related goods and services carried out within Tasmania, even if the actual building work is performed in another state. This comprehensive reach means it applies even if the contract itself specifies that it should be governed by the laws of another jurisdiction. It reinforces Tasmania's strong public policy stance on payment security.
Okay, that's very broad. But are there carve-outs, exceptions?
Yes, for all its breadth, there are some important exclusions you definitely need to be aware of, as these define the boundaries of the Act's reach. Firstly, the Act does not apply where a payment claim has already been made in another jurisdiction for the same matter.
Right, no double dipping.
Exactly. It sensibly prevents double dipping, ensuring a party cannot pursue the same payment under multiple state laws simultaneously. That would just create chaos. Secondly, it doesn't apply to contracts that form part of a loan agreement, a contract of guarantee, insurance, or indemnity. These are typically financial instruments with their own specific regulatory frameworks, not directly about payment for construction work itself.
Okay, financial agreements are out. What else?
Furthermore, contracts where the payment, the consideration, isn't calculated by reference to the value of work or services are also excluded. The Act is fundamentally about progress payments for work performed or services rendered. So if the payment structure is entirely different, maybe a fixed fee for a consultancy project, irrespective of hours worked, or the value provided, it likely falls outside the Act's scope. And contracts where a party undertakes work or supplies services as an employee are excluded. This Act is for independent contractors and businesses in the construction chain, not for employment relationships. Those are governed by separate industrial laws.
Employees are covered by different laws. Got it.
And finally, specific classes of contracts can be prescribed as excluded by regulations, although our commentaries didn't mention any currently prescribed in Tasmania. But the Act does allow for that possibility, providing some future flexibility if needed.
That brings us to a really tricky, often problematic area in construction contracts, those pay-when-paid clauses. They can cause immense headaches for subcontractors down the line. How does the TANS Act address them?
Yes, the dreaded pay when paid. That's a critical point, and it's one of the most powerful protections embedded within the TAS Act. The Act explicitly prohibits pay when paid clauses.
Completely prohibits them.
Completely. These are contractual provisions that make one party's payment explicitly contingent on them first receiving payment from a third party. For example, a subcontractor's payment might be made conditional on the head contractor first receiving payment from the ultimate client. It's a common tactic that effectively pushes all the payment risk down the contractual chain onto those least able to bear it.
So the Act just says no.
Under the TAS Act, such clauses have absolutely no effect. They are simply void and unenforceable, full stop. This is a powerful and direct protection for subcontractors and suppliers. It ensures they don't have to wait indefinitely for their payment because of delays or disputes higher up the chain that are completely beyond their control. It directly supports that pay now, argue later principle by removing these kinds of external payment dependencies. It basically says you've done the work under your contract, you're entitled to be paid for it, regardless of whether your client's client has paid them yet.
That's a huge protection. And can you work around that? Can you agree in a contract not to use the Act?
No, and this is just as important. You cannot contract out of the TAS Act. Any contractual provision that attempts to exclude, modify, or restrict the operation of the Act, or that purports to defer its operation, is void.
Void. So even if you sign it, it doesn't count.
Exactly. It means the protections offered by the Act are mandatory and cannot be circumvented by contractual agreement. So even if both parties sign a contract agreeing to override parts of the Act, perhaps to extend payment terms beyond what the Act allows, or to try and reintroduce a pay-when-paid clause in different words, those specific clauses would be unenforceable in relation to the Act's provisions. This underscores its public policy purpose. It's designed to protect the industry's cash flow for the greater good, and individual contracts cannot undermine that fundamental objective. It ensures that the Act's provisions are the absolute baseline standard, regardless of what private agreements attempt to state. It's a non-derogatable right for those working in construction in Tasmania.
Okay, so we've talked a lot about the why and the what of the TANS Act, its principles, its unique quirks, what it covers, what it doesn't. But now let's get down to the real brass tacks. If you're out there, on site, maybe you've poured the concrete, you've installed the wiring, you've done the work, and you're waiting for your money. How do you actually activate this powerful safety net? You mentioned the first step, arguably the most crucial, is the payment claim. Can you walk us through how to initiate that process correctly?
You're absolutely right. The entire process begins and hinges on what's called a payment claim.
Yep.
It's the formal written request for payment that fundamentally kickstarts the whole security of payment mechanism. And understanding its precise requirements is absolutely essential for anyone wanting to successfully use the Act. Procedural errors here can be fatal to your claim later on.
Okay, so who can actually make one of these claims?
First, let's consider who can make a claim. Pretty much any person who has undertaken construction work or supplied related goods and services under a construction contract can make a payment claim. This applies universally. Whether you are a head contractor dealing directly with a client or a subcontractor dealing with a head contractor, or even a supplier providing materials to a project. The Act is designed to protect all participants across the entire contractual chain, ensuring that everyone gets a fair shot at prompt payment for their efforts.
Right, so anyone doing the work or supplying stuff, when can they make the claim? Is there a specific time?
Yes, the timing is key. You can only make a claim on or after a reference date. Now, this reference date is either a specific date for progress payments that's agreed upon and explicitly specified in your contract. So if your contract says payments are due on the 15th of each month for work completed by the end of the previous month, then the 15th is your reference date. Simple. If the contract is silent on this, if it doesn't mention reference dates, the Act provides a default. It defaults to the last day of the named month in which the construction work was first carried out, and then the last day of each subsequent named month.
Okay, so the end of the month if the contract doesn't say otherwise.
Correct. That provides a clear default if your contract isn't explicit. And it's crucial to note, only one payment claim may be served for each reference date. This prevents multiple, confusing claims for the same period and keeps the process clear and orderly.
One claim per period, got it. Are there deadlines for serving the claim? Like, can you wait forever?
No, absolutely not. There are strict time limits for serving a claim. A payment claim must be served within the period determined in your contract if it specifies one. If your contract doesn't specify a time, then the default is it must be served within 6 months after the construction work was last provided or the related goods and services were last supplied, whichever period expires later.
6-month default. Is that the absolute limit?
Well, unlike some other jurisdictions, the TAS Act also states that unless the construction contract provides otherwise, a payment claim generally cannot be made 12 months after the construction work is finished or related goods and services to which the claim relates were last supplied. This creates an ultimate long stop date, a final deadline for claims, preventing them from lingering indefinitely and ensuring a degree of finality.
12 months is a final backstop.
Okay.
Now, the claim itself, what absolutely must be in it for it to be valid? This sounds critical.
It is absolutely critical, and this is where many claims unfortunately fall over if not done properly. It must be in writing. It must be clearly addressed to the person liable for payment, the respondent, and it must state the claimant's name clearly. It must also identify the specific construction work or related goods and services in sufficient detail to enable the recipient to properly assess the claim.
Sufficient detail. What does that mean in practice?
It isn't just about listing a total amount owed. It's about providing enough granular information, maybe the scope of work completed, the relevant dates, materials used, contract references enough for the other party to understand exactly what work or supplies are being claimed for and evaluate it fairly. It needs to clearly indicate the amount of money being claimed. And crucially, this is the one that catches people out. It must explicitly state that it is made under the Building and Construction Industry Security of Payment Act, 2009.
You have to write those exact words.
Yes, or words to that very clear effect. That exact statement or something unmistakably conveying it must be on the claim. If it's not present, it can invalidate the entire claim, making all your effort potentially futile. It's like having all the right ingredients for a recipe but forgetting to actually turn on the oven. No matter how good the ingredients are, the cake won't bake if you miss that step.
That's a vital tip. Okay, so you've got the claim written correctly. How do you actually deliver it? How do you serve it?
Finally, let's talk about how to serve a claim. You have a few options. Payment claims can be served personally, literally handing it to the right person, by lodging it at the other party's ordinary place of business during business hours, or by post or fax to their business address. And as we mentioned earlier, email service is also possible if the person has agreed to it in advance. That agreement is vital. You absolutely cannot assume email service is acceptable without prior written consent.
And keeping proof is important, I imagine.
Absolutely essential. A key piece of advice here. Always keep robust evidence of service. whether it's a signed receipt for personal delivery, a courier tracking confirmation, a fax transmission report, or a delivery read receipt for an agreed email. Having clear, undeniable proof that the claim was served on time and in the correct manner can be the difference between a successful claim and one that gets rejected purely on procedural grounds before you even get to the substance. The procedural exactness of this step cannot be overstated. It's the foundation upon which the rest of the Act's powerful mechanisms are built.
So you've meticulously prepared and sent off that payment claim, dotted the I's, crossed the T's, got your proof of service. The ball's now in their court. But what happens if they don't agree with the amount? Or worse, what if they just completely ignore it? This is where the pay now, argue later principle truly gets its teeth, isn't it? Ushering in the next stage, the payment schedule, and, if necessary, the whole adjudication process. Can you explain that next step for us?
You've hit on the crux of the Act's enforcement power. This leads us directly to the payment schedule and then, if needed, the adjudication process. This is truly the heart of how the Act forces that pay now, argue later mechanism into action.
Okay, so first up, the payment schedule. What is that exactly?
Let's start with the payment schedule. If the recipient of your payment claim, who we now call the respondent, does not intend to pay the full amount you've claimed, they must respond with a payment schedule. This isn't optional if they want to dispute the amount. This is their formal opportunity to set out what they do propose to pay, if anything, and crucially, why any part of your claim is being withheld or reduced. It's their formal response to your payment claim, and it's absolutely essential for the process to move forward if there's a dispute. Without it, the Act basically assumes they owe you the full amount claimed.
They must respond. How quickly? Are there tight deadlines here too?
Yes, the time frame for a response is incredibly strict, designed deliberately to keep the payment process moving quickly. They have 20 business days after receiving the payment claim if it relates to a residential structure, and the respondent is the owner and not a building practitioner. That's that slightly longer time frame we discussed for homeowners. For all other cases, meaning commercial contracts or residential contracts where the respondent is a builder or developer, they only have 10 business days.
Only 10 days. That's fast.
It is fast. And missing this deadline has severe consequences, as we'll discuss in just a moment. These tight deadlines are the Act's way of preventing intentional delays and forcing a prompt, formal response to your payment request.
Okay, so what information must be in this payment schedule?
What a payment schedule must include is also very specific under the Act. It must clearly identify the payment claim it's responding to. Seems obvious, but essential. It must clearly state the amount the respondent proposes to pay. This is officially called the scheduled amount. This could be the full amount, a partial amount, or even zero. If this scheduled amount is less than what was claimed, the schedule must clearly state why and provide specific detailed reasons for withholding payment.
Specific reasons? Like what?
General objections like the work was substandard or materials were late are absolutely not enough. They won't cut it. Specific reasons, ideally backed by evidence or contract references, are key. For instance, they must detail which part of the work was allegedly deficient and why, or which specific materials were not supplied as agreed and the consequence. This level of detail is critical for both parties to understand the precise basis of the dispute and for any future adjudication.
Okay, that makes sense. But what if they just don't send one? What if they miss that 10 or 20-day deadline?
Ugh. Now here's where the Act truly bites. The consequence of not providing a payment schedule is significant. If a respondent fails to provide a valid payment schedule within that strict time frame, they become automatically liable to pay the full claimed amount set out in your original payment claim.
The full amount. Just like that.
Just like that. There's no argument about the amount at that point, at least not under the Act's immediate process. It becomes an enforceable debt. This is a powerful enforcement mechanism, specifically designed to compel a timely response and prevent passive resistance or stonewalling of payment claims. It essentially transforms your payment claim into an immediately recoverable debt if no proper dispute is formally raised on time via a payment schedule. It is a very, very serious consequence for inaction by the respondent.
Wow. Okay, so assuming they do provide a schedule, or if they don't and the full amount becomes due, when does the actual payment need to be made? What's the payment due date?
The payment due date is also clearly defined by the Act to avoid ambiguity. Payment becomes due either on the specific date specified in your contract, if there is one, or if the contract doesn't specify a payment due date, it defaults based on when the payment claim was served. It's 20 business days after the payment claim was served for those residential structure claims, where the respondent is the owner and not a building practitioner. For all other cases, it's 10 business days after the payment claim was served. These clear deadlines are crucial for maintaining the flow of cash and ensuring there's no ambiguity about when payment is actually expected.
And if they still don't pay by that due date, even if they sent a schedule agreeing to pay something.
Then interest on overdue payments becomes payable. This interest is calculated at the higher rate of either the rate prescribed under the Supreme Court Civil Procedure Act 1932, TASE, or the rate specified in the construction contract itself, if it has one. This acts as a further financial incentive for prompt payment, compensating the claimant for the delay and adding a penalty for noncompliance with the payment obligations.
Okay, so that covers the payment schedule stage. But what if the payment isn't made by the due date, or the amount offered in the payment schedule is disputed by the claimant? They think they're owed more. This is where the actual adjudication comes in, right? How does that fast-track independent review work to force the pay now part when there's still disagreement?
Exactly. This is where the fast-track dispute resolution process truly kicks in, involving an independent adjudicator. It's the core mechanism for enforcing pay now, argue later, when a payment schedule is either unsatisfactory, unpaid, or wasn't provided at all.
So how and when do you start that? When to apply for adjudication?
The timing for applying for adjudication is absolutely critical and depends entirely on the situation you find yourself in after the payment schedule stage. There are a few distinct scenarios. Scenario 1. Payment schedule provided, but amount is less than claimed. If you've received a payment schedule, but the scheduled amount is less than what you claimed, and you disagree with their reduction, the claimant must apply for adjudication within 15 business days after receiving that payment schedule. This is for when you've received a response, but you believe you're still owed more based on your claim.
Okay, 15 days if you disagree with the scheduled amount. What's scenario 2?
Scenario 2. Payment schedule provided, but scheduled amount not paid by due date. Alternatively, if a payment schedule is provided, and maybe they agree they owe you a certain amount, but that scheduled amount is then not paid by the due date. In that case, the application must be made within 20 business days after the due date for payment has passed. This covers situations where the respondent has acknowledged an amount is due, but then simply failed to honor their own payment schedule.
Right, so they admit they owe it but don't pay. 20 days for that. What's the trickiest one you mentioned?
Scenario 3. No payment schedule provided at all, and no payment by the due date. This is the most complex sequence, and it's designed to give the respondent one final chance before adjudication. If no payment schedule was provided by the initial deadline, and the full claimed amount wasn't paid by the due date, the claimant must first serve a second notice. It's sometimes called a notice of intention to apply for adjudication on the respondent. This must be done within 20 business days of the original payment due date.
A second notice, like a final warning.
Exactly. This second notice essentially tells the respondent, you didn't provide a payment schedule, you haven't paid, I intend to apply for adjudication, but you have one last chance. It gives the respondent a second chance period of 5 business days from receiving this notice to provide a payment schedule. If still no payment schedule is provided within that 5-day window, the claimant then has 15 business days after the end of that 5-day period to make the actual adjudication application.
Wow, that's a specific sequence.
It is incredibly specific. Missing any of these steps or deadlines in this precise sequence can be fatal to your claim. You lose your right to adjudicate for that payment claim. Strict adherence to these timeframes is paramount. It's like navigating a legal minefield where one wrong step, one missed deadline, can blow up your entire claim under the Act.
Okay, so assuming you've navigated the timing correctly, what goes into the actual adjudication application itself?
Yep. The adjudication application requirements are also quite precise. The application must be in writing. It has to be made to an authorized nominating authority, or ANA. These are independent bodies responsible for appointing the adjudicators. The application must clearly identify the payment claim and, if one was provided, the payment schedule you're seeking adjudication on. It must include detailed submissions supporting your claim. This is where you put your arguments, attach your evidence, calculations, contract clauses, correspondence, everything backing up why you're owed the money. It must be accompanied by the ANA's application fee. And importantly, a copy of the entire application must be served on the respondent at the same time you lodge it with the ANA. This ensures procedural fairness by giving the respondent immediate notice of your application and all your arguments.
Okay, application lodged and served. What can the respondent do then? Can they argue back?
Yes. Once the application is made and served, The respondent then has the opportunity to submit an adjudication response. However, and this is a crucial point that really reinforces the importance of that initial payment schedule, a respondent can only lodge an adjudication response if they had already provided a valid payment schedule to the claimant within the original timeframes, the 10 or 20 business days.
So if they missed the first deadline for the payment schedule, they can't respond to the adjudication at all.
That's generally the case. If they didn't provide that initial payment schedule on time, they'd typically lose their right to formally respond to the adjudication application itself. This is a very strong incentive to provide that initial payment schedule properly and on time. The response time frame for the respondent, if they are entitled to respond, is the later of 10 business days after receiving the adjudication application, or 5 business days after receiving notice that an adjudicator has formally accepted the application.
And what can they put in their response? Can they raise new arguments?
No, generally not. The response may also only contain reasons for withholding payment if those reasons were already included in their original payment schedule. An adjudicator must not consider an adjudication response lodged out of time or one that contains new reasons for non-payment that weren't flagged in the initial payment schedule. This effectively limits the scope of the adjudication to what was initially disputed in the payment schedule, preventing new arguments or ambushes from being sprung at the last minute during the fast-track adjudication process.
Right. Keeps it focused on the original dispute. So then it goes to the adjudicator's determination.
Correct. The adjudicator, who is appointed by the ANA and is an independent expert in construction law and practice, then makes their decision. They must make their determination within 10 business days after receiving the adjudication response, or when it was due if none was permitted or lodged, unless both parties agree to grant an extension. The adjudicator determines the amount of the progress payment, this is called the adjudicated amount, its due date, and any interest payable. They also have the power, as we discussed, to determine who is responsible for their fee.
And what can the adjudicator actually look at to make this decision?
They are strictly limited in what they can consider. They must base their decision primarily on the provisions of the TAS Act itself, the relevant terms of the construction contract, the payment claim and any supporting submissions from the claimant, the payment schedule, if provided, and any supporting submissions from the respondent, if permitted, and the results of any inspections they might personally conduct, although that's less common. The determination must be in writing and include the reasons for the decision, unless the parties agree otherwise. This ensures transparency and provides a basis for understanding how the adjudicator reached their conclusion.
Okay, the decision is made. What are the consequences of adjudication? This is where it really matters, right?
Absolutely. This is where the rubber truly meets the road and the pay now part gets enforced. Firstly, the payment obligation. If an amount is determined payable by the adjudicator, the respondent must pay that adjudicated amount by the date set in the determination. If no date is set, the default is within 5 business days of the respondent receiving the determination. This is the immediate pay now command enforcing the adjudicator's decision quickly.
And if they still don't pay, even after the adjudicator's decision?
Then the claimant has powerful enforcement options. They can obtain an adjudication certificate from the ANA that lodged the adjudicator. This certificate is a crucial document. It can then be filed as a judgment for a debt in a competent court like the Magistrates Court or Supreme Court, depending on the amount. Once filed, it becomes enforceable just like any other court order or judgment debt. This is a truly powerful mechanism allowing swift recovery of funds without needing to go through a full-blown, lengthy lawsuit to prove the debt again. It bypasses much of the traditional court process for debt recovery, making it highly efficient.
So you can use the courts to enforce the adjudicator's decision quickly. Is there anything else the claimant can do if they're not paid?
Yes, there's another significant right. The claimant gains the right to suspend work. If the adjudicated amount is not paid by the due date, the claimant can choose to suspend carrying out further construction work or supplying further goods and services under the contract. They must give the respondent at least 2 business days written notice of their intention to suspend. And critically, the respondent then becomes liable for any loss or expense incurred by the claimant because of this suspension. This could include demobilization costs, standing time for equipment, disruption costs, etc. This puts considerable leverage in the claimant's hands, allowing them to legally stop work and potentially accrue further costs against the non-paying party until the adjudicated amount is settled. It underscores the serious implications of failing to pay an adjudicated sum and acts as a powerful deterrent.
That's a truly robust system for enforcing immediate payment. Suspending work is a big deal. But even with an adjudicator's determination maybe filed in court, is that the absolute final word legally? Or can those decisions still be challenged in court somehow?
That's a complex but crucial area, and it really highlights the delicate balance the Act tries to strike between ensuring speedy payment and allowing for ultimate justice on the underlying dispute. While the TAS Act aims to limit judicial challenges to maintain that pay now, argue later principle, it does not completely remove the rights to judicial review by the courts.
So how does that work? Didn't you say they couldn't challenge it in the debt recovery proceedings?
That's right. There are restrictions in debt recovery. When an adjudication certificate is filed as a judgment debt in court, the respondent is generally not entitled to bring a cross-claim against the claimant, raise a defense based on the underlying contract dispute, or challenge the adjudicator's determination within those specific debt recovery proceedings. This helps maintain the pay now, argue later immediacy. The court's role at that specific stage is primarily just to enforce the debt certificate, not to re-examine the adjudicator's findings on the merits of the original dispute.
Okay, so you can't fight the debt itself in that enforcement process. But you said review is still possible. How?
Yes. Despite those restrictions in the enforcement proceedings, Tasmanian courts retain their inherent power to review an adjudicator's decision for what is called jurisdictional error. Think of jurisdictional error as the adjudicator fundamentally stepping outside their proper lane, acting beyond the legal authority or the specific jurisdiction granted to them by the Security of Payment Act. It's not about what they decided, whether you agree with their calculation of the money owed or their interpretation of a contract clause. It's about whether they even had the legal right to make that decision in the first place, based on the strict rules and boundaries set by the Act. This power of judicial review for jurisdictional error is consistent with fundamental legal principles established in landmark high court cases across Australia, like Chase Oyster Bar, Play Limited v. Hamo Industries, Litited Limited, and Craig v. South Australia. The courts retain oversight to ensure statutory decision-makers act within their lawful power.
Jurisdictional error. Okay. What kind of things count as that? What are the common grounds for jurisdictional error?
Common grounds typically fall into a few categories. One is if the original payment claim itself did not comply with the mandatory requirements of the Act. If the very foundation of the claim was flawed, for instance, it didn't explicitly state it was made under the TAS's Act, or didn't adequately identify the work, then the adjudicator may not have had jurisdiction to even hear it. The whole process might be invalid from the start. Another broad and significant category is a denial of natural justice. This is a fundamental legal principle, essentially meaning a party was not given a fair hearing.
Denial of natural justice. Like bias.
Bias can be one aspect. Yes, a reasonable apprehension of bias on the part of the adjudicator. But it also includes other procedural fairness issues. For example, an adjudicator failing to consider submissions properly put before them by a party at all, or making a decision based on a completely new issue or line of reasoning that was not raised by either party, without giving the parties an opportunity to comment or respond to that new issue first. Or if an adjudicator simply doesn't read parties' submissions properly, or fails to mention a critical issue that was squarely put before them and decides on it without allowing parties to address it, that could lead to a finding of a denial of natural justice.
So it's about the process being fair, not just the outcome.
Exactly. It's important to differentiate this from simple errors of fact made by the adjudicator, or maybe the adjudicator just not fully appreciating the significance of a party's submissions or evidence. Those kinds of errors within jurisdiction, are generally not sufficient on their own to invalidate a determination through judicial review. The court isn't there to simply rehear the case and substitute its own view on the merits. It's looking for procedural unfairness that amounts to a denial of basic justice, or the adjudicator acting beyond their statutory power. It's quite a high bar to meet for a successful challenge.
So it sounds like the courts are very particular about the adjudicator following the correct process laid out in the Act, rather than simply second-guessing their financial findings or contractual interpretations. Have there been any notable cases in Tasmania that illustrate these points?
Yes, there have been several case examples that help clarify this complex area and show how Tasmanian courts approach it, often aligning with New South Wales principles. In Skill Tech Consulting Services, Puplet Limited v. Bold Vision Plitty Limited back in 2013, this was actually the very first reported case connected to the TAS Act. The Supreme Court confirms that the established principles for granting a legal remedy called certiorari must be followed for adjudications. Think of certiorari as a court order to effectively quash or invalidate a decision made by a lower authority, like an adjudicator, because that authority acted outside its legal boundaries or denied natural justice. It's like the court saying, this decision is legally flawed and therefore invalid, so we're setting it aside. The court in Skilltech acknowledged the complexity of the construction dispute, the limited time the adjudicator had, and the sheer volume of material involved, which obviously made the adjudicator's task difficult. But it ultimately held that mere errors of fact made by the adjudicator were not enough to invalidate the determination. There needed to be a jurisdictional error. This case also dealt with issues around multiple payment claims being served, clarifying which one would be considered valid under the Act's rules.
Okay, so errors of fact aren't enough. What about procedural errors?
That came up in R.V. McDessie, Ex parte Walton, in 2014. In that case, an adjudicator's determination was quashed by the court. Why? Because the adjudicator had failed to properly consider the respondent's submission due to an error of law they made regarding the time limits for the response. The court found this amounted to a failure to observe procedural fairness, highlighting that even seemingly technical procedural errors by the adjudicator can lead to a quashed decision if they effectively deny a party a fair opportunity to present their case according to the Act's rules.
Right, sticking to the rules is key. What about raising new issues?
That was clarified in Modscape Pulley Ltd v. Francis in 2017. The court confirmed that if an adjudicator considers making a determination based on grounds or issues that are different from those presented by either party in their submissions, they must notify the parties of this new issue or line of reasoning and allow them an opportunity to make submissions on it before making the final decision. Failure to do so typically results in a lack of procedural fairness and could be grounds for jurisdictional error. However, the court also clarified that the adjudicator is not required to share their provisional conclusions or tentative findings for parties to critique before the final decision. Their obligation is to ensure parties have a chance to respond to the issues being considered, not to the adjudicator's preliminary thoughts on those issues.
That's a subtle but important distinction. Any other examples?
One more recent one is Parliament Square Hobart Landowner Pretty Limited v. Tonkin in 2020. In that case, it was held that the adjudicator did act within their jurisdiction when they determined whether certain contractual terms had been subject to waivers and/or estoppel based on the conduct of the parties. This confirms the broad scope of contractual and factual issues an adjudicator can legitimately consider and decide upon as part of their determination, as long as it's necessary to determine the amount due and they follow the correct procedures under the Act.
So the courts can review for jurisdictional error. Can they also step in to stop the money being paid out immediately if there's a challenge, like an injunction or a stay?
Yes, courts do retain the power to grant an injunction to prevent the claimant enforcing the adjudication certificate, or a stay of execution of a judgment debt obtained via an adjudication certificate. However, this would typically only happen in very rare circumstances. The applicant, usually the respondent who has been ordered to pay, would need to show a very high risk that the claimant would be unable to repay the money if a later full court case determined they were not actually owed it. For example, if there's strong evidence the claimant is insolvent or on the brink of bankruptcy.
So it's about preventing an irreversible loss.
Exactly. The court has to balance several factors: the need to uphold the Act's pay now, argue later policy, the strength of the argument suggesting the adjudicator's decision might be flawed on jurisdictional grounds, and the likelihood of the claimant's inability to repay the money if the decision is eventually overturned. It's a high threshold to meet and certainly not automatic. It's a discretionary measure reserved for situations where there's a real risk of significant injustice if the money changes hands immediately and can't be recovered later.
And overall, the legal principles seem pretty aligned with New South Wales.
Yes, fundamentally, Tasmanian courts have largely adhered to the persuasive authorities established in New South Wales courts, given the substantial similarities in the legislation. This strong alignment is expected to continue, providing a good degree of consistency in how these laws are interpreted across different jurisdictions in Australia, which is definitely a benefit for national businesses operating in multiple states.
So we've talked quite a bit about the adjudicator's crucial role in making these swift decisions. But who exactly are these adjudicators, and who are the authorized nominating authorities, the ANAs, that appoint them? What rules do they operate under to ensure fairness and impartiality in this whole process?
Good question. These are absolutely critical players in the security of payment ecosystem. You could think of them as the gatekeepers and the independent referees of the entire system. Their integrity and strict adherence to the rules are paramount for the Act to function effectively and fairly.
Let's start with the adjudicators themselves. Who can be one? What are the adjudicator eligibility requirements?
Okay, an adjudicator must be a natural person, so an individual, not a company. They need to have qualifications, expertise, and experience as determined by the Security of Payments official in Tasmania. It's interesting to note that at the time our commentaries were compiled, such specific requirements hadn't actually been formally determined or published. This leaves some flexibility in who can serve in this crucial role, likely focusing on practical experience and relevant professional backgrounds. However, there are strict disqualification rules. An adjudicator is strictly disqualified if they have a material personal interest in the outcome of the adjudication.
Material personal interest.
Yeah.
Like a financial stake.
Yes. Or potentially a close relationship with one of the parties or some other conflict that could reasonably be perceived as affecting their impartiality. If an adjudicator becomes aware they have such an interest after accepting an application, they must cease dealing with the application as soon as practicable and notify the parties and the ANA. This is vital to avoid any perception of bias. The Act also explicitly states that an adjudicator cannot be a party to the construction contract they are adjudicating. Seems obvious, but it's clearly stated to ensure absolute impartiality.
What if a party thinks the adjudicator is biased or disqualified, but the adjudicator disagrees and won't step down?
The Act provides an important mechanism for that exact situation. If a party believes an adjudicator is disqualified, perhaps due to a perceived conflict of interest, and the adjudicator does not recuse themselves, that party can apply to the magistrate's court for a review of the adjudicator's decision not to disqualify themselves. This provides an important check and balance, allowing for judicial oversight if there are genuine, substantiated concerns about an adjudicator's impartiality or eligibility. It's a safeguard against potential conflicts of interest actually tainting the process.
Okay, so that's the adjudicator. What about the organizations that appoint them? The authorized nominating authorities, ANAs.
Right, the ANAs. These are organizations, often professional bodies or dispute resolution centers that have been officially authorized by the relevant minister in Tasmania. Their primary and extremely important role is to receive adjudication applications from claimants and then nominate qualified adjudicators to decide those applications. They are responsible for ensuring that the adjudicator they refer an application to is actually qualified under the Act's requirements and, importantly, confirms that the adjudicator is not a party to the construction contract in question and doesn't have any obvious conflicts. ANAs themselves must meet specific criteria set out in ministerial guidelines and conditions of authorization. This ensures they operate professionally, maintain registers of qualified adjudicators, and manage the nomination process impartially and efficiently.
Is there any oversight of the ANAs themselves?
Yes, the Security of Payments official has the power to impose or vary conditions on an ANA's authorization, providing a regulatory framework for their conduct and ensuring they maintain high standards. And if an organization is unhappy, maybe their application to become an ANA is refused or conditions are imposed that they disagree with, they can apply to the magistrate's court for a review of that decision too. At the time of the commentary, there were 4 ANAs practicing and authorized in Tasmania. This shows there's a selection of recognized bodies for claimants to choose from when lodging an adjudication application, offering some choice and competition in the market.
4 ANAs, okay? And what about the practicalities? How do adjudicators get paid, and are they protected if someone disagrees strongly with their decision? Let's talk about adjudicator fees and liability protection.
Good practical points. Regarding fees, both the claimant and the respondent are jointly and severally liable to pay the adjudicator's reasonable fees and expenses. Typically, the adjudicator will direct the parties to pay in equal proportions, 50-50-50, unless they decide otherwise based on conduct, like we discussed, with the power to award costs for frivolous behavior. Jointly and severally liable means the adjudicator can pursue either party for the full amount of their fees if the other party doesn't pay their share. So if your opponent ducks out of paying their half, the adjudicator can still legally require you to pay the whole amount, though you might then have a separate claim to recover that half back from your opponent later. It's a mechanism designed to ensure the adjudicator gets paid for their work, regardless of disputes between the parties about who should ultimately bear the cost.
Right, ensures the adjudicator gets paid. And liability. Can they be sued?
To encourage experienced professionals to take on these demanding roles and make fair decisions without undue fear, adjudicators and ANAs are generally protected from personal liability for actions or omissions done in good faith when exercising their functions under the Act. This statutory immunity is vital. It mitigates the personal risk associated with making sometimes contentious determinations under tight deadlines with complex information. It allows them to focus on the merits of the case as presented according to the Act without the constant fear of being personally sued by a disgruntled party just because they lost. Of course, this protection wouldn't apply if they acted in bad faith or outside their powers.
that protection makes sense. So, after all this discussion about the mechanics and the nuances, what's the overall sentiment or perhaps any data regarding the effectiveness of the TAS Act? Is it actually doing what it's set out to do in practice? Is it working on the ground?
Well, based on the commentaries we've looked at, the overall perception is that the TAS Act is generally seen as effective in Tasmania. It's considered a useful tool. There have certainly been successful debt recoveries reported under the Act. One notable example mentioned was a large matter where a claimant successfully recovered $1.6 million through the adjudication process.
$1.6 million. That's significant.
It certainly is, and an example like that powerfully demonstrates the Act's capacity to facilitate significant payments, even for very large and complex claims. It underscores its utility for businesses needing to recover substantial sums quickly. Now, while the commentaries didn't provide broad statistical data specific to Tasmania's usage, things like the total number of adjudication applications lodged each year, or the average processing times, or the aggregate value of adjudicated amounts across the state, that specific high-value case certainly highlights its potential impact. It suggests that when the Act is utilized correctly, following all those procedural steps we discussed, it can be a very powerful tool for ensuring financial stability and resolving payment disputes efficiently.
That's a strong testament to its impact, especially that one significant example you mentioned. So looking ahead, what does this all mean for the future? Are there ongoing discussions or perhaps future changes expected for the TAS Act, or has it found its stable footing now after those earlier reform attempts didn't proceed?
Well, as we noted earlier, while Tasmania has seen those various reform efforts proposed back around 2014-2015, the TAS Act ultimately remains largely in its original 2009 form. The proposed amendment bills lapsed. This suggests a degree of stability and perhaps even a level of satisfaction within the industry or government with its current legislative framework, despite the passage of time and the evolution of security of payment laws in other states. The commentaries consistently emphasize that the Tasmanian courts largely continue to follow the persuasive authorities established in New South Wales, mainly due to the identical or very similar nature of many key aspects of the legislation.
So that link to New South Wales law remains important.
Very much so. This ongoing consistency means that legal precedents from the more mature New South Wales jurisdiction often provide significant guidance for understanding how the TAS Act is likely to be interpreted and applied in practice here in Tasmania. This offers a certain valuable level of predictability for legal practitioners and parties involved in construction disputes in Tasmania. They can look to a well-established body of case law from a larger jurisdiction to help inform their decisions, their strategies, and their understanding of how the Act operates. This whole deep dive really reveals how a seemingly complex piece of legislation like the TAS Act actually aims to simplify a core, often debilitating problem in the construction industry, just ensuring people get paid for the work they do. That central pay now, argue later principle fundamentally shifts risk and maintains critical cash flow, allowing projects to progress even when disagreements arise. It keeps the wheels turning. But this very expedience, while absolutely vital for industry health, sometimes invites a deeper question, doesn't it? At what point does the necessary speed of adjudication potentially clash with the need for thorough consideration of really complex factual disputes that might genuinely take much longer to unravel properly? This tension, while managed within the Act's framework with its specific rules and limitations, is always sort of simmering beneath the surface of quick adjudication. It invites us all, I think, to consider that ongoing balance between efficiency, getting money flowing fast, and achieving ultimate, perhaps more detailed justice in these rapid dispute resolution mechanisms within such a vital economic sector. It's a constant balancing act.
Before you go, please don't forget to share, like, or subscribe. Also have a look at other episodes and visit CM Guide website for better insights on this topic.